Good morning. Are we
Good
up there?
morning.
But they prefer to retain their contract.
Good morning. We'll get started here shortly.
Thank you. Not hearing him.
Do you see the ad litem? Mhm.
All right, sorry, I was in the middle of another meeting. You probably saw my lips moving. Okay, Chambers County Probate Court come to order. Melinda, are you on? Oh,
I'm Melinda today.
I'm Melinda today. All right, if you'll all raise your right hand, anyone that's going to testify.
Your right hand. Raise your right hand.
Go ahead, Kristen.
Swear or affirm the testimony you're giving today is true and correct, so help you God.
I do.
I do.
All right, thank you, Kristen.
You're welcome.
First on the docket, 21 CPR 017, State of Hayden, Divion Hooper.
Yes, sir.
Good morning.
Good morning. So I'll start. Your name is John Elmer Moore,
Yes,
and you're the great grandfather of Hayden Hooper.
yes,
And he is now how old?
20 years old now.
20 years old. And you were advised by the Star, Texas Star Kids, Texas Children, and the other doctors at Texas Children's Hospital, Dr. Hoke and others, that he needed to have a guardian.
Yes,
And you and Gloria, that's your daughter or sister, daughter, are the ones who share in the care of Hayden.
yes,
And that's why we're filing as co-applicants to be the guardians of the person and the estate of Hayden Hooper.
yes,
He has some disabilities, does he not?
yes,
He has, as set out in the proof of facts that you have signed and is now filed before the court, he's not able to make decisions for himself.
yes.
He's
He's not able.
He's not able.
Yeah.
And you can't leave him alone, can you?
No.
He has a severe epileptic seizure
Yes,
problem that he has to be monitored 24/7, correct?
Yes, yes,
He also has an intellectual disability. He cannot make decisions for himself.
yes,
All right. And you have attached to our application the doctor's report requiring this and showing the condition of Hayden, and you're offering that from Dr. Mohammed Ahmed in Baytown to the court as Exhibit B and Exhibit A. He did one in 20 and just recently, December 15th of 21, before we filed this. And you're asking the court to appoint you as the co-guardians to do all the powers that you have asked for in the application, but also contained in the order. He can't make any decisions for himself, can he?
No, he cannot.
And as far as the estate, he receives SSI, Social Security Disability,
Yes,
and that's about $800 now as of January.
yes,
And that's all that he has.
yes,
But you're asking to be appointed guardian of the estate to be able to receive those funds and pay them out for the benefit of Hayden.
yes,
We have listed a lot of powers that y'all are asking to be granted in this order. And we just went over them together. But if I asked you all of these page 3 and 4 powers, and then the limitations of the ward's right, which goes along with the fact that he can't make a decision for himself,
that's correct.
not even where he can live, because he wouldn't be able to do that in his best interest.
Yes,
So you're asking the court to approve this. There is no real estate of this child,
no,
only Social Security disability.
yes,
So do you believe that $50 cash would be a sufficient recommended bond? There's a bond required in all guardianships, and you believe that? Neither one of you are going to do anything but spend that money for Hayden, are you? But you're saying that a $50 cash bond you would be paying, not from Hayden's money, but from yours. And
Yes.
you're asking the court to approve the guardianship, and you were met, Mary Beth Nelson met with you last Thursday,
yes,
and telling the court, well, we have paid her the $600 fee for her services. And I think she will have filed a report. I'm not sure of that. We didn't have Windstream yesterday, Judge. So ask the witness.
Ms. Nelson, good morning.
Good morning, Judge.
You may proceed.
I believe that I missed the first part of this hearing and I apologize, but it looks like you're at the end. Your Honor, I did meet with my client Hayden Hooper and the proposed guardians, and I have reviewed the court's file. And I believe that this is very much in Hayden's best interest that the court appoint these two parties as guardians. I have not filed a report. I have received my fee. And I have no further questions for the witnesses.
Okay, and you have signed off on the order appointing permanent guardian of the person and of the state.
I have, Your Honor.
Okay, so you agree with that? And I'm going to approve the order appointing permanent guardian of the person of the state. Ms. Nelson, the $50 cash bond, you feel like sufficient from the testimony that was given?
Your Honor, I do.
Okay, then I'm gonna approve that also.
Thank you, Judge.
Thank you. All right, calls number 22, CPR 0009, estate of Rebecca Gail Stevens.
Ready, Your Honor.
Good morning, you may proceed, Counselor.
Okay, Your Honor, I'd first like to call the Solarskis as witnesses to the decedent's handwriting and signature. Jean Solarski,
There you
Yes,
go.
could you please state your full name?
Jean Marie Solarski.
And how were you acquainted with Rebecca Gail Stevens?
We've known Becky and Eric for about 25 years as friends.
And you had the opportunity to see her handwriting and signature on multiple occasions, is that correct?
Yes, that is correct.
And I've sent you a copy of a document dated July 30th, 2017, which purports to be a photocopy of Ms. Stevens' last will, all in her handwriting and signed by her. Is that correct?
Yes,
And on that date, she was over the age of 18 and of sound mind. Is that correct?
yes.
No further questions for this witness, Your Honor.
Next witness, Counselor.
David, will you please state your full name?
David Francis Solarski.
And how were you acquainted with Rebecca Gail Stevens?
I've known Eric and Becky for over 25 years. We've been friends. He's in my car club. I've known him for a long time.
And you'd had many opportunities to see Miss Stevens' handwriting and signature. Is that correct?
Yes, that's correct.
And I've sent you a document, photocopy of a document dated July 30th, 2017, which purports to be Miss Stevens' last will. Do you recognize her handwriting and signature in that document?
Yes, I certainly do.
And on that date, was she over the age of 18 and of sound mind?
Yes, she was.
Pass the witness, Your Honor.
No questions, counsel.
I'd like to call the applicant, Eric Stevens.
Here.
Mr. Stevens, will you state your full name?
Eric Lance Stevens.
And did your wife die on August 11th, 2021 in Wallaceville, Chambers County, Texas, at the age of 66?
Yes, she did.
And did she have a fixed place of residence in Chambers County on the date of her death?
Yes, she did.
And she had not applied for or received Medicaid benefits after March 1st, 2005. Is that correct?
She had not.
And I asked the court to take judicial notice that the document submitted to the clerk is an original. The handwritten document dated July 30th, 2017, which you have a copy of, purports to be your wife's last will and was never revoked as far as you know. Is that correct?
That is correct.
And no children were born to or adopted by your wife after the date of the will. Is that correct?
That is correct.
And your wife never had a dissolution of marriage after the date of the will. Is that correct?
That is correct.
And no state governmental agency of a state or charitable organization is named in the will as a devotee. Is that correct?
That is correct.
And you have full personal knowledge of your wife's financial affairs. Is that correct?
That is correct.
And there's no necessity for an administration of her estate because there are no debts owed by your wife that aren't secured by liens on real property. Is that correct?
That is correct.
Pass the witness.
No questions, counsel.
Okay. Your Honor, we ask that you admit this holographic will to probate as a muniment of title. And as the applicant is the only beneficiary, ask that you waive the 181-day fulfillment requirement affidavit.
So now, thank you, counsel. Have a good
Thank
day.
you. Thank you.
Mr. Stevens.
May we be dismissed?
You may be.
Thank you.
Thank you. All right, cause number 16, the state of Neil Allen Smith. Good morning, Ms. Price.
Thank you, Judge. I'll start with my client, if I may.
MC.
Can you state your name for the court record, please?
Tanya Lokay Smith,
And what is your relationship to the decedent?
spouse.
And did Mr. Smith die on November 24th, 2021 in Harris County at the age of 50?
Yes.
And did Mr. Smith reside and have a fixed place of residence here in Chambers County at the date of death?
Yes.
And he was married once before you, and that marriage was a very short time and ended in divorce without any children, correct?
Correct.
And then Mr. Smith and you married, and how long have you two been married?
24 years.
And during that time, there were two children born of that marriage, correct?
Correct.
And what were their names?
Rhett Allen Smith and Hunter Neal Smith.
And were there any other children born or adopted by Mr. Smith?
No.
Did he bring any other children into his home?
No.
And so the only two children is your marriage to him are your two children, correct?
Correct.
So pass this witness, Judge.
Spark. You muted, Richard.
I have no questions for her at this time, Your Honor.
Okay. All right. So I've got two witnesses here, Judge. I'm gonna let you get up and let Stacy get here. And Judge, these two witnesses have been sworn in.
Okay, good morning.
Thank you.
You
So
may proceed.
thank you, Judge. Stacy, if you'll state your full name for the court record, please.
Stacy Tilton, him and wife,
And what was your relationship to Mr. Smith?
friend,
And how long have you known Mr. Smith?
about 30 years.
And so you would be pretty conversant with the family history of Mr. Smith, correct?
Correct.
And you know that he was married to for before Tanya, correct?
Yes,
And that was without any children, correct?
correct.
And that he's married to Miss Smith. And how many children do they have?
2.
And you are not here to testify that you've been paid for your testimony today,
No.
and you have no chance of inheriting from
No.
this estate. Pass this witness, Judge.
Mr. Park.
Yes, ma'am. I spoke with you on March the 21st. Is that correct?
Yes, sir.
And we went over the same questions that Ms. Price asked you. There are no other children born of him other than the 2 children that you're mentioned. Is that correct?
That is correct.
All right. And you know of no children that were born during his first marriage?
Correct. No.
Pass the witness, Your Honor.
Okay, call your next witness.
Thank you, Judge. All right. Okay, Tracy, if you'll state your name for the court record, please.
Tracy Lee Patillo,
And Tracy, what is your relationship to Mr. Smith?
friend,
And how long have you known Mr. Smith?
also approximately 30 years.
And are you aware that he had any other children other than the 2 children named here today?
No, I'm not.
And do you know if he ever talked about having a will?
No.
And to your knowledge, this is, other than the first marriage, these are the only 2 children. He never brought any other children into the marriage.
That's correct.
Pass this witness, Judge.
Ms. Patillo, I spoke with you on 3/21. Is that correct, regarding this estate?
Yes, sir.
And we had a similar discussion that you just had with Ms. Price. And we determined from our discussion that you'd known Mr. Smith approximately 30 years, and that the 2 children that are named Rhett and Hunter are the only 2 children ever born of him, as far as you know.
Yes, sir. That's correct.
Okay. And there are no other children that you know of that he adopted or took in for any reason?
No, not to my knowledge.
Pass the witness, Your Honor.
Judge, that's what we have for the heirship. And then if I may proceed with the administration portion.
You may. I don't see an order for heirship.
It should be. I filed them both. Yes.
Okay, well, I'm gonna go ahead and approve the order. Mr. Park, you agree with it? On the heirship affidavit?
Excuse me, I didn't hear you, sir.
Have you seen the order for the heirship?
Yes, sir, I have, and I signed it.
Okay. then
It's
I'm
here.
gonna
I
approve.
don't, it didn't make it to your desk. My
No, that's
apologies.
fine. I'll approve it later, but I'm gonna verbally approve it and I proceed.
Thank you, Judge. Ms. Smith, there is a necessity for the administration of Mr. Smith's estate. Is that correct?
Correct.
And you are named as independent administrator by both your children, correct?
Correct.
And they agree for you to be that independent administrator.
Correct.
You are qualified, not disqualified, to serve as independent administrator, to serve without bond.
Correct.
Okay. Judge, and we're asking that you name her as independent independent administrator to serve without bond.
So done.
Thank you, Judge. Are we
Thank
excused?
you. You are. Take care, ma'am.
Thank you.
All right, cause number 24, the state of James Earl Hance. Mr. Dawson, good morning.
Ready, Your Honor.
Who's that outlaw you got there with you?
Good morning, Judge. I have Monette Porter, who's a licensed attorney, and she's assisting me today.
Good morning.
I'd say she's a young lawyer, but everybody is younger than me this day and time. So we're ready to proceed on not only the heirship, but also the request for independent administration.
You may proceed, Counsel.
Go ahead.
Your Honor, we'll first call our witness, Linda Kane.
Where's Mr. Hance?
Is she on mute?
She needs to get off mute.
Can you turn your mute off, Ms. Kane?
Is that Don Snyder's? Yes, to unmute yourself, ma'am. Still muted.
No.
There you go. All right, go ahead.
Please state your name for the court.
Linda Faye Hance Kane.
And how do you know the decedent, Mr. James Hance?
He's my brother.
Okay. And Mr. Hance resided in Chambers County, is that correct?
Yes, ma'am.
And he was married twice to Miss Donna Hans, which he
Yes.
was divorced, correct?
Yes.
And then they had a child, Miss Tony Watson, is that correct?
Yes.
And there were no other children born to that marriage or any other marriages, is that correct?
That's correct.
Okay. And at the time of his death, Mr. Hance was single, is that correct?
Yes, he was.
Okay. And do you have no financial interest in this case, is that correct?
No, ma'am, I do not.
Wait a minute. Oh, not
And-
y'all. Hold on. I'm gonna put myself on mute. Go ahead.
Okay. And just to make sure that I understand, there is no other children other than born to the marriage or to Mr. Hance other than Miss Tony Watson. Is that correct? There's
That's
only one child. Okay. Correct.
Only one child, Tony.
Okay. I'll pass the witness.
Mute myself. Okay.
Now,
so
can you hear me?
I can hear you. You may proceed.
All right. Ms. Kane, I'm Georgia Clapper, the ad litem in this case, and we've looked a lot of places to see if we could find an heir for the heirship other than Miss Watson. You're correct on the two marriages, but the first marriage was in Liberty, correct? And the divorce was in Liberty?
I'm pretty sure, yes, ma'am.
Right. And that's the marriage in which the applicant, Miss Tony Watson, was born.
Yes.
All right.
Mhm.
And the second one was over in Orange, and they were only together like 2 or 3 months. And then they divorced. No child was born to the marriage or subsequent after the marriage, to your knowledge or to the records. Is that correct?
That is correct.
All right. And as his sister, you knew all this, and you'd know if he took someone into his house to raise as a child under this probate code that we have to look at.
Oh, yeah.
But he didn't do that either, correct?
No, he did not do that. He lived alone.
And y'all looked for a will to see if he had made some sort of arrangements for after his death.
Yes, because he spoke of that, but there was no will. He didn't ever go through with that. As a matter of fact, when he was on the way to the hospital, not knowing that he wouldn't come out, he had called my nephew and he wanted him to go and visit him, but that never happened.
And you believe it's in the best interest that Tony, his only daughter, be the person to handle the administration of his estate.
Oh, yes, ma'am.
All right, pass the witness, Judge.
Okay, call your next witness, Counsel.
Judge, we would now call Charles Harmon. Is that your name, sir?
Charles T. Harmon.
And you go by Chuck, is that
Yeah.
correct?
Yeah.
How'd you get him out of Old River?
And you're a resident of Chambers County, is that right?
Yes, ma'am.
Actually,
Yeah.
you live out there at 565 and 3154?
2354.
Okay, all right. And how many years did you know Mr. Hance?
About 40.
So would it be fair to say that you knew James Hance pretty well?
No.
Did you know him well enough to know if he had any children?
Yes.
Did he have just one child?
Yes.
And was that Tony Watson?
Yes.
And was there any other child that you know of?
No.
And he died as a single person, is that correct?
Yes.
And in the 40 years that you knew him, you had occasion to see him from time to time and maybe have a Coke or coffee with
Yeah.
him?
Yes.
And what kind of business were you in?
Built boats.
Okay. And so you saw him with some regularity to be acquainted with
Yes,
whether or not he was single, whether he was married. Is that right?
yes,
And do you believe that there was only one child, and that was Tony Watson?
yes,
And at the time of his death in January 2022, he was a single man. Is that right?
yes,
And you never heard him speak of any other child, did you?
no,
And you have no financial interest in this case. Is that
No.
right?
no,
You're just an impartial and disinterested witness, except that you knew the guy for many, many years, right?
yes.
I pass the witness, Judge.
Ms. Clapper.
I think all of the questions have been answered already. Thank you, Mr. Hampton, for being here. And Harmon, I'm sorry, said the wrong last name. I have one question. Did he ever mention to you a will? His sister has already said he wished he had done it. But did Mr. Hance ever mention to you that he had a will, or that he wrote out a one-page will or anything like that?
No,
All right. Well, thank you very much. And Judge, I'd like to offer my report. I went into a lot of places looking for heirs, unknown heirs, finding that second marriage kind of caused us to do a little more search. And so we have listed out there what we checked, and every district clerk's office, and also the marriage license and the county clerks of the different counties, and found nothing other than the 2 marriages, and only one child was born. There is no other child that we were able to find. So I do believe that there is only one heir, and it is Ms. Watkins.
I'll approve the judgment declaring heirship. And may proceed with the administration, counsel.
Okay, we'll go ahead with the administration. Go to the administration. Call to the votes.
Your Honor, I'd like to call our applicant, Tony Watson.
Tony, muted.
This is Tony. Will you please state your name for the court, please?
Tony, she's still muted. There you go.
My name's Tony K. Watson.
Okay. And how do you know the decedent?
He's my father.
And he resided in 1310 Lake Charlotte on Wallaceville. Is that correct?
Yes, ma'am.
And that is in Chambers County. Is that correct?
Yes.
And he was indeed unmarried twice. He was married to Donna Murphy Hans, and that marriage terminated in divorce in 1985. He was married for 18 years to her, and that is your mother. Is that correct?
That is correct.
Okay. And you are the one and only child, only heir. Is that
Yes.
correct? Okay. And although your father was married again subsequent, there were for approximately 6 months, there were no children born to that marriage. Is that correct?
That is correct.
And at the date of his death, he was not married. Is that correct?
That is correct.
Okay. And decedent had no will. Is that correct?
That is correct.
And a necessity exists for the administration of this estate. Is that correct?
Yes, ma'am.
And a diligent search has been, you stated that there was no will, but a diligent search has been looked, there's been a diligent search for that will, and yet has not produced one. Is that correct?
That is correct.
Okay. And you are qualified you have not been disqualified from being an independent administrator. Is that correct?
That is correct.
And you have no criminal record. Is that correct?
That is correct.
Go to the end of the order.
Your Honor,
Approve the order.
I request that the court approve the order granting the independent administration of Ms. Tony Watson, and to appoint her as independent administrator of the estate.
Easy for you to say.
It's a mouthful here.
I know. Okay, I'm gonna approve the order granting independent administration authorized letters of independent administration. And you did a good job, ma'am.
Thank you, Your Honor.
Chuck, you did a good job testifying.
Yeah.
I didn't really believe you, but because I know you too well. All right. We're done. Thank you so much.
Thank you, Judge.
Thank you,
Take care.
Your
Have a
Honor.
good day.
You too.
All right, cause number 27, the state of Linda Stevens Cheney. Davidson.
Good morning, Your Honor.
Good morning.
I'm
you
not sure
testifying?
my client was here whenever you swore everyone in, so out of an abundance of caution, let's go ahead and do that.
Okay, is that
It's Linda Skelton is her name.
Ms. Skelton? Raise your right hand, please.
Hi. Do you swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
You may proceed, Counselor.
Thank you, Your Honor. Please state your name for the court.
Linda Nieto Skelton,
What was your relationship to the decedent Linda Stevens Cheney?
lifelong friend.
Okay, and Linda died on January 4th of this year, 2022, in Webster, Harris County, Texas, at the age of 72. Is that right?
Yes,
And this court has jurisdiction and venue, and that she had a fixed place of residence in Chambers County at the time of her death. Is that right?
yes,
And to the best of your knowledge, the document that we've submitted to the court as the last will and testament of Linda that my office prepared, dated February 22nd, 2017, was never revoked, was it?
no,
Your Honor, I would request that you take judicial notice that you've got the original last will and testament in your file.
Okay.
Thank you. No state governmental agency or charitable organization is named in the will as a devisee, are they?
no,
And after the date the will was made, there were no children born to or adopted by the decedent, were there?
no,
And neither was there a marriage dissolved after the date the will was made, was there?
no,
And her will named you to serve as independent executor. And you are not disqualified to serve in that capacity, are you?
no,
And so, Your Honor, we're asking that the will be admitted to probate, that upon filing of her oath, Linda Nieto Skelton be appointed as independent executor of the estate without bond. It is a non-taxable estate, would request that appraisers be waived.
Well done. Thank you, Counselor.
Well, thank you, Your Honor. I was gonna say, I like your haircut.
Thank you. At no maintenance due.
Yeah, exactly.
I actually need a haircut. Mine's getting a little long.
Well, have a great day. Appreciate it.
You too.
May we be excused?
You may be.
Thank you.
Cause number 28, last but not least, Mr. Lefebvre, good morning.
Good morning, Your Honor.
You may proceed.
My name is John Lefebvre, and the decedent Anna Elizabeth Harrington died on January 31st, 2021 at her residence in Beach City, Chambers County, Texas, at the age of 77 years. And as the court takes judicial notice, 4 years have not elapsed since the date of her death. The court has jurisdiction and venue over the estate, and that the decedent was domiciled and had a fixed place of residence in Chambers County on the date of her death. You have her original will, Your Honor, that she did die testate. Her will was signed on August 3rd, 2027, and was witnessed, and there's a self-approved affidavit with the will. That the citation has been served and returned, required by law, that there is a necessity for the administration of the estate. And to my best knowledge and information, the decedent never revoked her will. No state governmental agency or charitable organization is named as a devisee of her will. There was no child born to or adopted by her after the date of her will, and no marriage of the decedent was ever dissolved after the will was made. She named her husband, Gary Norris Harrington, to serve as independent executor, and he is qualified and not disqualified from accepting letters testamentary. And ask the court to approve the order, appoint him as independent executor without bond, and have no further testimony, Your Honor.
Okay, I think the will was signed on the 3rd of August, 2017.
Yes, sir.
I think you said 2027, but I may have just heard it wrong. Just for-
Yeah, but no, hey, look, we're on the same page. It's
Yeah, I know.
August 3rd,
All right.
2017. Okay.
I hereby order the probating the will and authorize letters of testamentary. Thank you, Counselor.
Thank you, and you have a good day, Your Honor.
You too. Thank
And it
you.
was a privilege being last in your court today.
Yeah, whatever. You're full of it.
Anyway, it's life. Take care and God bless.
You too.
Did Melinda bring you that judgment to sign?
I got
Not Melinda.
yes, I had both of them. I didn't have either one, so both of them came up.
Great.
All right. All right. Thank you.
Bye.
Bye.